It's March 11th. Welcome to yes2hellwith.com. In federal statutes, words are not used casually. They are chosen deliberately, and the meaning of those words determines how the law operates. One of the most important words in statutory construction is the word includes. Most people assume the word simply means, for example. They read a statute and see the word includes and presume a loose illustration of something broader. But statutory language does not operate that way. Congress itself explained how this word is supposed to function. In 26 U.S.C. 7701C, Congress states, "The term includes and including shall not be deemed to exclude other things otherwise within the meaning of the term defined." And this tells us something very important. The word includes introduces items that fall within the meaning of the defined term. But those items listed are not random examples. They are deliberate indicators of how Congress chose to frame the scope of the statute. But when Congress uses that word in the definitional section of the Internal Revenue Code, particularly in the provisions that establish the statutory framework of jurisdiction, the language must be read carefully. Courts have long recognized that statutory language must be interpreted according to the established rules of construction. One of the oldest of those rules is expressed in the Latin maxim, inclusia unius est exclusio alterius. This means that the inclusion of one thing implies the exclusion of others not expressed, or those that are not within the class identified. In other words, when lawmakers deliberately identify certain items within a definition, the choice of those items is legally significant. This principle becomes especially important when interpreting tax statutes, because the Supreme Court has repeatedly held that taxation laws must be interpreted strictly according to the language enacted by Congress. In Gould versus Gould, the court stated, quote, "In the interpretation of statutes levying taxes, it is the established rule not to extend their provisions by implication beyond the clear import of the language used," end quote. The court repeated the same rule in United States versus Merriam. Tax statutes are not to be extended by implication beyond the clear import of the language used. And these decisions establish a fundamental rule of law. Tax laws must be applied as written, not expanded by implication, presumption, or administrative interpretation. This is why the word includes becomes so important in the definitional structure of the Internal Revenue Code. When Congress uses the word includes in the statutory framework that describes the jurisdictional terms of the code, the language must be interpreted according to the words Congress actually chose. Congress has demonstrated throughout Title 26 that when it intends to explicitly enumerate geographic jurisdictions, it knows how to do so clearly and unmistakably. In some provisions of the Internal Revenue Code, Congress expressly lists, quote, "the 50 states," end quote. When Congress uses that language, there is no ambiguity. But in other provisions within the definitional framework of the code, Congress chose different wording and relied upon the term includes instead. Under the rules of statutory construction recognized by the Supreme Court, the language of tax statute cannot be expanded beyond what Congress actually wrote, which means that the meaning of statutory definitions must be determined by the language of the statute itself, not by presumptions about what Congress might have intended. This is why careful attention to statutory language matters, because the enforcement of federal tax law ultimately depends upon the definitions enacted by Congress itself. Understanding how Congress used the word includes is therefore essential to understanding how the statutory framework of the IRC operates. And it is precisely this kind of statutory interpretation that raises legitimate questions concerning congressional intent, which is why at the conclusion of this series, those who have the Statement of Understanding program will send a letter to members of Congress requesting clarification regarding the statutory definitions contained in 26 U.S.C. 7701 and how those definitions relate to the income tax imposed under 26 U.S.C. Section 1. And as always, may truth reign supreme.